Hello friends, welcome to my channel again. This is a girl Mercy. If you're a returning subscriber, I appreciate you a lot. If you're new to this channel, please hit the subscribe button, share this video, but I know the content I share in this video will edify you, help you in your practice. This Lawyers Info Hub is a platform I reach out to lawyers, I reach out to non-lawyers, I talk about law practice, talk about tips for excellent practice, all aimed at you having a smooth sail in your practice. So today I'm going to talk about how to prepare a petition for dissolution of marriage. Now, where you have a client who has come for you to help him or her dissolve his or her marriage, after taking down the story and you've gone through the checklist which I have earlier talked about, I'll put up the link to that other video because I've been running a series on matrimonial proceedings. If you check the checklist and the petition, well, let's say if you file it, it will sail because time is of essence with respect to filing of petition. The issue of living apart, we have the 2-year rule, we have the 3-year rule. Now if all is set and you don't want to file a petition, you need to understand the things you need to do, the subheadings, how to prepare it and all of that, so that it will be comprehensive. Now for the content of our petition, aside heading it in the court where you want to file it, now these are very key things you need to note. The introduction, you have to note the names of the parties, their occupation, where they are residing, that is their address. Now you have to also note the address of the respondent, very important. Now on the issue of marriage, you have to state where they had their wedding, date, when they were born, that is the birth of the parties, where they are domiciled, that their residence. You have to also state that fact, state the particulars of their cohabitation, when they live together as husband and wife, and the point at which they started living apart. Very important. You have to also state the children of the marriage. Where there is children of marriage, you state their names and the dates they were born. But where there is not children of the marriage, you state none in that portion. Also look at whether there was previous proceedings. Sometime before a petition for dissolution of marriage was brought, maybe the parties have tried issue of a judicial separation, things like that. You notice if there has been any previous proceeding, but there has not been anyone, you state none. Then the facts, which is the gist of the petition, why client, who is the petitioner, the petitioner in this respect wants to dissolve his or her marriage. This is where they state out what has happened to the marriage, what led to the separation. Now these facts must be tied to section 15 sub 2 of the Matrimonial Causes Act, where they've listed grounds for dissolution. So whatever story you are going to write down must relate to at least one or two of those grounds, and the fact that the marriage has broken down irretrievably. That is very important. You have to know the issue of condonation, connivance, and collusion. You have to know that part, that once parties connive to bring their marriage to dissolve their marriage, because it won't fly. So there must not be any collusion, connivance, or condonation. Then the proposed arrangement of the children, arrangement for the children. If they are children of the marriage, what is the proposed arrangement? Does the petitioner want custody? Does he want shared custody or sole custody? Issue of access and maintenance. You have to state what you want, how you want the petitioner to take care of the children, the payments, the money, or if there's need for alimony, you have to state all that, different provisions, health, all that you need the petitioner to do, or you have to state it. Now if there's issue of property, issue of settlement of property is very important. And this aspect, you state out all the properties jointly owned by parties in which they got during the pendency of the marriage. State it, and whichever one the petitioner wants to take, or okay, I want this for settlement or whatever, you state all of that. Now if you want them to be sold, okay, I want this, or wanted this one to be sold, then I'm giving this, or I want just whatever you want to transfer to the settlement of property. You also need to state it properly in your petition. Very important. Then if there are other ancillary matters, you can also state it. You can know what are the orders you're seeking from the court. Order for the dissolution of the marriage. Very important. You need to state what you're seeking from the court. Also, the conclusion is where you now state the person who settled the petition, which is you. Remember, you have to sign that portion, state your address. Also, note that there should be a verifying affidavit. Very important. The verifying important in affidavit is a very integral part of your petition. Without your verifying affidavit, your petition is incompetent, and any objection raised on that fact will be upheld by the court. And once your petition is incompetent, it cannot fly. So note that you must add your verifying affidavit, then certificate of reconciliation, because it assumes that counsel must have advised the client on possible means of reconciliation in the marriage. So you have to also state the certificate of reconciliation. I have to do another video on the concept of verifying affidavit, because most people do not know the importance of that document. So far I've listed out what should be contained in your petition. So ensure that